Hi, welcome to our channel of IGNOU audiobooks, Indira Gandhi National Open University, School of Law, SOL, Diploma in Paralegal Practice, DIPP, BLE 001 Introduction to the Indian Legal System, Block 2 Rights and Duties, Unit 5 Directive Principles of State Policy and Fundamental Duties, 5.1 Introduction. India was a country in turmoil when the makers of our constitution were drafting the broad set of rules that would bind us as a nation. The partition riots were wreaking havoc in some parts of the country, in others, people were starving, and in most parts, most people were illiterate and uneducated, yet, we, the people of India, decided to set ourselves some fairly tough goals. We decided that this would be a sovereign republic and that we would ensure that all of us were able to live our lives to the fullest. Were these goals impossible, and if they are, is it any use trying to believe in these goals and achieve them? If they are impossible, then there is clearly no point in putting them down in our constitution, but we found a way of making these seemingly impossible goals seem achievable. How did we do this? In order to achieve these lofty ideals, we set ourselves some clear milestones, some fundamental objectives that we should all try to achieve. These milestones are known as the Directive Principles of State Policy. These are the steps in the ladder that may help our country transform impossibility into reality. If the directive principles are duties imposed on the state, our constitution imposes certain fundamental duties on the citizens too. Even though both sets of duties cannot be enforced, they act as guiding principles and help us, state and citizens, to achieve the promise we have made ourselves in the preamble. In this unit, we will turn our attention to these milestones, these goals that we have set for ourselves. We will try to understand how they are effective in helping India achieve what others may think impossible. 5.2 Objectives. After studying this unit, you should be able to explain the basic nature and concept of the directive principles of state policy. Under the Indian Constitution, explain whether the directive principles are effective at all, and if so, how they can be implemented. Identify what these directive principles are, and be able to evaluate the progress that successive governments have made in achieving them. Analyze the relation between the directive principles and the fundamental rights. Explain the nature and importance of fundamental duties. 5.3 Nature and scope of the directive principles of state policy. We are used to living in a democracy. We are used to having a voice in the government's decision-making process. We are used to being able to throw the current government out if we feel that they are not doing a great job. Why do we do this? Why do we think this is important? Perhaps the answer lies in the fact that our ability to think, to reason, and to question the actions of those in power is not automatically suspended the day the elections are over. As citizens in a participative democracy, we do not stop thinking about the future of our country just because we have elected a new government and put a new set of people in power. We do this because human thought is fickle, and sometimes those in power may not be consistent in their decision-making. However, if the government is already in power, what can we do if we do not like its policies, except to criticize it through peaceful means? Don't you think it would be a good idea to have a broad path laid down for the government to follow, so that it does not stray too far from what we, the people of India, want it to do? It is exactly this purpose that the directive principles of state policy fulfill. The directive principles are like a set of ideals or goals that each government should try and fulfill. No matter what the policies or plans of the political party in power, it can only act in a manner that would be consistent with these broad ideals. Otherwise, we would have a situation where the country changes direction dramatically every time there is an election. We would be no better than a country that is ruled by a series of dictators, with each dictator in turn doing whatever she wishes with the country. Seen like this, the directive principles help guide the government of the day and bring about a sense of stability to the direction of the country's progress. This means that the directive principles are a way of ensuring that the country progresses consistently over time rather than heading off in a different direction every 5 years or so. The directive principles can also be seen as a check upon the arbitrary use of state power. This means that the government of the day cannot destroy all the work that has been put into developing the country over the years simply because that work does not agree with its own whims and fancies. Our directive principles, therefore, is the steady anchor that holds the national ship steady amid the turbulent tides of time. But does this mean that they bind us to decisions made decades ago, which we cannot change at all? Of course not. If enough of us believe that the directive principles need to be changed, this can always be done by way of an amendment to the Constitution. To last questions before we look at what these directive principles actually are. If these goals are difficult to achieve, some may even say impossible within the limited terms that governments have in power, then do we have the right to go to court against a particular government for its failure to implement any directive principles? Clearly not. This is the reason why the directive principles are not enforceable like your fundamental rights. Very simply put, you can go to a court and ask for an order, which we now know is called a writ, to make sure that you get your fundamental rights. But you cannot go to a court and ask for an order to be passed against the government simply because it has not been able to achieve one of the directive principles of state policy. Finally, does this mean that the directive principles are meaningless? No. As we saw, they give direction and purpose to the government's policies and are vital as a benchmark against which we can judge the government's performance. These are also given a lot of importance in the hierarchy, the order of superiority in our Constitution, to the extent that a law that enforces a directive principle of state policy may not be struck down by the courts, even if it restricts a fundamental right. We will see how this works in more detail in a later part of this unit. 5.4 The Directive Principles as a Roadmap. Now that we have a fair idea of what the directive principles of state policy are supposed to do, let us try and see what exactly they say. What are these ideals that we are supposed to achieve? Once we know this, we can better understand how they can be put into effect and, very importantly, judge how successful we have been as a nation in achieving these goals since independence. The directive principles are in Part 4 of our Constitution. You would remember that Part 3 talks about the fundamental rights. The fact that the directive principles are put immediately after the fundamental rights shows how important our constitution makers considered them to be. The first two articles in Part 4, Articles 38 and 39, tell us very clearly how the directive principles are meant to be used. Article 37 tells us that the directive principles cannot be enforced in a court of law. We saw the meaning of this in the previous section. You cannot go to court and ask for an order against the government because you think that they have not achieved any of the directive principles. The next article, Article 38, though, clearly states that state should try and keep these principles in mind when creating policies for the country. It says that the state should strive for the welfare of its subjects, people like you and me, by securing and protecting social order, in which justice, social economic and political, shall inform all the institutions of life. Notice how these ideals of justice are the same as the ones set out in the preamble of the Constitution. Does this give you an idea of how important the directive principles are considered to be in the constitutional framework? What, then, is social justice? The Supreme Court explained this concept in the case of Air India Statutory Corporation v United Labour Union, AIR 1997 SC 645 as a complex set of social changes that are necessary to make the lives of all the people of the country more livable. This applies especially to the poorer and more deprived sections of society. The idea, then, is to try and bring all the people of the country to a level where they can enjoy a standard of life that allows them complete room for growth and development. Does this concept seem familiar to you? Yes, that's right. It is exactly the same concept we saw when we were reading about the concept of equality under Article 14 of the Constitution in the previous unit. Now, let us ask ourselves what inequalities exist in our country's society, which the directive principles seek to remove. If you think about it carefully, some of these inequalities would be the inequalities between men and women, such as the fact that women are sometimes not paid as much as men, even if they do the same amount of work, the inequalities between the rich and poor, which often arise because the poor do not have access to the means of production, which means that they do not have the ability to create wealth, for example by building their own businesses or factories, the inequalities between those who have access to proper medical facilities and those who do not, and the inequalities between children who have access to education and those who do not. Such children who are unable to get an education are often the same children who suffer exploitation. Article 39 sets out these inequalities and directs the state to strive for their removal. This article has been put into effect in part. We now have a law in the country which prohibits the employment of children below the age of 14 in any hazardous industry. You may sometimes have wondered how the government, which is based in the capital, can think about the problems of all the people in the country and how it can possibly solve the problems that arise in the smallest villages. You are not alone in wondering about this. Article 40 encourages the development of a system of local self-government. It says that the state should try and set up systems like village panchayats. This is because the people who are on the ground are best able to identify their problems and can find the best solutions for them. This, too, has been put into effect to some extent, and panchayats are a common feature in India. Not only that, in some states there also exists a system for recall of candidates elected to these local bodies. If the people do not like the work that elected candidates have done while in office, they can vote them out of power. Article 41 says that the state, within the limits of its economic capacity, should try and secure the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement, and other such cases. You need only look around you to realize that this ideal is far from realization. Not only that, the courts have interpreted this principle in a slightly narrow manner. They have said that if somebody loses their job because of a failure of the government, say because the government cannot supply electricity to a factory, then the government does not have to pay compensation to that person. The next three articles, 42, 43, and 43 focus on the right to work and encourage the participation of workers in management. The next directive principle we shall read about is slightly controversial. Article 44 says that the state should try and put in place a uniform civil code in the country. Today, the personal laws governing each person depends upon their religion. This means that the laws relating to matters such as marriage, divorce, succession, and adoption are different for people from different religions. Since we have a large number of religions coexisting in our country, this ideal has been difficult to realize. Do you think that the state should at all try and realize this directive principle? Is it fair for the government to interfere in such matters? On the other hand, can the state allow inequalities between people from different religions to continue? For example, a woman belonging to one faith may have the right to maintenance after divorce, but a woman belonging to another faith does not. A tricky question. Indeed, one directive principle that has been realized in theory is Article 45, which encourages the state to try and provide for free and compulsory education for all children till the age of 14. We now have a fundamental right under Article 21 that provides for this. However, but you would agree that there are still a lot of children below the age of 14 who do not have access to education and are forced to work for a living. Article 46 gives sweeping directions to the state to strive for the welfare of the weaker sections of society. But the problem is that this term has not been clearly defined anywhere in our Constitution. Traditionally, though, the focus under this article has been on groups such as the scheduled castes and scheduled tribes. The next article, Article 47, focuses on health and nutrition. It encourages the state to raise the level of nutrition and standard of living of its people. Furthermore, it also encourages the prohibition of the consumption of intoxicating drinks and drugs, except for medicinal purposes. A large percentage of the people in our country, more than half, work in the agricultural sector to earn their living. If this is the case, it is obvious that the state should try and take steps to improve and modernize agriculture and animal husbandry in the country. This is exactly what Article 48 talks about. That article also goes on to direct the government to try and prohibit the slaughter of all milch and draught cattle. The landscape of our country is dotted with historical monuments. We have a rich heritage, a combination of many cultures from different parts of the world, and these monuments are symbols of that heritage. This is why Article 49 directs the state to take steps to preserve every monument, place, and object of artistic or historic interest. But think about the last time you took a holiday to visit such a place. Chances are that that monument would have been scarred by graffiti. The Taj Mahal, which is recognized globally as a symbol of Indian culture, is now being slowly destroyed. Pollution is ruining the marble of this monument. Do you think that this article has been realized? We know by now that one of the pillars of our system of government is the separation of powers between the executive, legislature, and judiciary. We have also seen how the judiciary is entrusted with the responsibility of keeping a check on the arbitrary use of power by the legislature and the executive. For this reason, Article 50 encourages the state to preserve and encourage the independence of the judiciary. You may have heard the phrase, "No man is an island." Similarly, our nation cannot survive by itself, cut off from the rest of the world. Article 51, the last of the directive principles, directs the state to try and promote international peace and security. This is necessary for India to gain its rightful place as one of the prominent nations of the world. Think about this, and perhaps India's struggle to gain a permanent place on the Security Council of the United Nations would make more sense to you. 5.5 Juggling priorities. The only problem with trying to achieve very difficult goals is that they may come at the cost of other priorities. Now that we have a good idea of what the directive principles of state policy are and how they are supposed to be used, let us understand what would happen if a law that tries to put a directive principle into effect restricts one of your fundamental rights. Let us take a small example to discuss this and to understand this better. Suppose the government of a particular state passes a law which says that since there is a shortage of agricultural labor in some districts in that state, there would be a ban on anybody working in the cotton industry in that state. The law says that if anybody tries to employ workers in the cotton industry, they would be punished. The reason offered for this is that this would free up enough people to work as agricultural labor, and that this is being done to enforce the directive principle. Under Article 48, which directs the state to promote agriculture, now, the cotton manufacturers in that state challenge this law in court, saying that it violates their fundamental right to freedom of trade, profession, occupation, and business under Article 19(1)(g). They say that if people are not allowed to work in the cotton industry, they would have to stop their businesses and close down their factories. How would you decide this case? The answer does not seem very simple, does it? On the one hand, you have a fundamental right, which is considered one of the most basic features of our Constitution. On the other, we have a directive principle of state policy, which is considered an ideal that the state must head towards. Some may even say that it is the very reason for the existence of the state. In the early years of independent India, courts used to lay much more emphasis on the fundamental rights, and if a law tried to restrict a fundamental right, it would be struck down even if it was trying to enforce a directive principle. But then, there was a realization that this would have a bad effect upon the concept of directive principles. If they are not enforceable in a court of law anyway, and if the courts strike down a law trying to put them in place on the grounds of a restriction on the fundamental rights, then Part 4 of the Constitution would be rendered completely meaningless. According to the Supreme Court, the fundamental rights and directive principles constitute the conscience of the Constitution, and both are complementary to each other. In many cases, the Supreme Court has interpreted fundamental rights on the guidelines supplied by the directive principles. The two have to be harmoniously construed. When a question is placed before the court about whether a law trying to enforce a directive principle that also restricts a fundamental right should be allowed to exist, the court will typically ask three types of questions. What is the extent of the restriction? Is it absolute or partial? If the restriction on the fundamental right is absolute, that is, complete, then the law would probably be cancelled. What purpose is the government trying to achieve through that law? Is it to enforce a directive principle? And is there a reasonable connection between that purpose and the restriction that has been placed on the fundamental right? This is also known as the nexus question. If the government can show that there is such a connection, and that putting that restriction in place would help the enforcement of the directive principle, then the court may allow the law to continue, otherwise, it would strike it down. Finally, the court will ask whether there was any way of enforcing that directive principle other than by placing a restriction on a fundamental right. If there does exist such an alternate way, then the court will strike down that law, and the government will have to adopt that other method if it really wants to enforce the directive principle. If there is no such other way, then the court may allow the law to stand. Now, let us try and apply these questions to the situation we discussed. Was the restriction absolute or partial? In this case, the restriction placed on the fundamental right of trade, profession, occupation and business of the persons employed in the cotton industry was complete. The law said that anybody trying to employ workers in the cotton industry would be punished. On this ground, therefore, the court may strike the law down as invalid. What was the purpose behind the law, and was there a nexus with that purpose? In this case, the purpose behind the law was to enforce the directive principle under Article 48. The government can argue that there exists a reasonable connection between this purpose and the restriction placed on the fundamental right under Article 19(1)(g). It can argue that the cotton industry is employing too many people, and that is the reason why there is a shortage of labor in the agricultural industry. On this ground, therefore, the court may say that the law is valid. Finally, let us consider if there was any other way of enforcing that directive principle. The government may argue that the only way to obtain agricultural labor in districts that were facing a shortage would be to prevent people from working in the cotton industry. But then, wouldn't it be a far simpler solution to have people from other districts come and work in the agricultural sector wherever there was a shortage? Of course. And wouldn't this mean that there is no need to place a restriction on any fundamental right? Again, the answer is clearly yes. On this ground, therefore, the court may hold the law to be invalid. Now, let us step back and consider whether the law would be valid. If you consider the responses to the three questions above and all the things we discussed, it would now be clear that the law will be struck down. What seemed a complicated question now has a fairly simple answer. 5.6 Evaluating our performance. We now have a good understanding of how the constitution makers expected the directive principles to work and what these directive principles are. We also saw the relationship between the directive principles and the fundamental rights, and we now understand that the courts always try and balance these interests using the doctrine of harmonious construction, which we discussed. But given all of this knowledge, we must now ask ourselves honestly as a nation whether we have achieved all these lofty ideals we set for ourselves. We may have thought of some fantastic goals and also put in place a good system to bring them to reality, but have the successive governments since independence really been able to do this? There is today a fundamental right to free and compulsory education for all children up to the age of 14 under Article 21. But we know that this ideal is far from the actual truth. There are still countless children who have to work in often hazardous conditions to survive. This is not a problem of the villages or semi-rural places alone. Cities are full of children who work at roadside restaurants, workshops, and even in people's houses as domestic servants. People belonging to the scheduled castes have had to struggle for their right to basic human dignity for centuries. The history of caste struggle in India is long and bloody, and even as recently as a few decades ago, organizations like the Dalit Panthers in Maharashtra were so frustrated at the ill treatment of their community by the government that they took to violent means to have their voices heard. While we cannot condone the use of violence as a means of protest in civil society, instances like this highlight the terrible conditions that people in our country are often forced to live in. Read the newspaper carefully for a week, and chances are that you would come across at least one story that talks about how a person belonging to a lower caste has been tortured and killed for an offense as trivial as taking water from the village well or entering the compound of a temple meant for the higher castes. Untouchability has officially been abolished, and this one measure has been successful to some extent. We now have the Prevention of Atrocities on Scheduled Castes and Scheduled Tribes Act 1989, which makes offences against people belonging to the scheduled castes punishable. Caste politics has become a feature of Indian politics, and caste often holds the key to unlocking the identity of the next government. This shows that the lower castes have at least been able to make an impact upon the electoral process. Reservations in educational institutions and in government jobs are a reality in India today. Even the so-called modern face of India bears its blemishes. Try and find out who the leaders of Indian industry are, and chances are that you would come across very few women. In many families living in the most metropolitan cities, girls find it difficult to convince their parents to let them pursue higher education. Dowry debts abound, unemployment is rampant, and state-run initiatives have had questionable impact upon this problem. Thousands of villages across the country still lack basic amenities like electricity and water. The judiciary is often asked to interpret the ideas set out in the directive principles, and the results have been mixed. For example, in one very famous case called the Shah Bano case, Muhammad Ahmad Khan v Shah Bano Begum and others, AIR 1985 SC 945, the Supreme Court upheld a Muslim woman's right to receive maintenance from her husband after divorce, a giant leap towards realizing the ideal of a uniform civil code set out in Article 44. But in another case, Delhi, Development Horticultural Employees Union v Delhi Administration, AIR 1992, SC 789, the Supreme Court said that the government did not have any obligation to provide regular employment to people who were rendered jobless once the government had ended any of its employment schemes. 2 steps forward, 1 step back. The report card, therefore, is mixed. There are more red marks than distinctions. Why do you think this has happened? Maybe, just maybe, the problem lies in the fact that most of us think that the responsibility for creating a true welfare state, in which all the people of the country can live in conditions that support their growth and development, is that of the government alone. The solution to this, though, is obvious. We have to stop thinking of this as somebody else's responsibility and start taking actions to remedy the wrongs we see. In the words of the father of the nation, be the change you want to see in the world. If we believe in and work towards realizing the ideals set out in our directive principles of state policy, we will not only have believed in, but actually made true innumerable impossible things before the day of Indian democracy has faded out. 5.7 Fundamental duties. Now that we have a better and clearer idea of what fundamental rights and directive principles are, we move ahead to another crucial feature of the Indian Constitution, the fundamental duties. As studied in the earlier units, Part 3 of the Constitution confers certain fundamental rights to its citizens and other individuals, and Part 4 imposes certain directives on the state to follow whilst enacting laws. However, the individual cannot just have rights and expect the state to abide by the directives while doing nothing to protect and promote the integrity and unity of a nation as a good citizen. This was the very purpose of the fundamental duties, to confer upon every citizen some specific responsibilities that naturally accompany the extension of certain freedoms. Fundamental duties were incorporated into the Constitution by the 42nd Amendment in 1976. Part 4A of the Constitution enlists the fundamental duties in Article 51, which lays down that it is the duty of every citizen of India to abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem, to cherish and follow the noble ideals which inspired our national struggle for freedom, to uphold and protect the sovereignty, unity and integrity of India, to defend the country and render national services when called upon to do so, to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and regional or sectional diversities, to renounce practices derogatory to the dignity of women, to value and preserve the rich heritage of our composite culture, to protect and improve the natural environment including forests, lakes, rivers, and wildlife, and to have compassion for the living creatures, to develop the scientific temper, humanism, and the spirit of inquiry and reform, to safeguard public property, and to adjure violence, to strive towards excellence in all spheres of individuals and collective activity, so that the nation constantly rises to higher levels of endeavor and achievement. As a result of the 86th Amendment of 2002, an additional duty was added to the existing ones. Article 51A (k) requires every citizen of India who is a parent or a guardian to provide opportunities for education to his child, or, as the case may be, ward, between the ages of 6 and 14 years. Very few constitutions of the world specifically provide for the duties and obligations of citizens. Among socialist countries, the Yugoslavian and Soviet constitutions lay great emphasis on citizens' duties. Among the democratic constitutions, the Japanese constitution mentions certain duties of its citizens. In Australia, Britain and Canada, the rights and duties of citizens are governed by the common law and its judicial decisions. A mere passing reference of duties is found in the French Constitution, whereas no reference to duties is found whatsoever in the American Constitution. This, however, does not mean that citizens of these countries are free to be undemocratic in their behavior. If we could imbibe the importance of our elementary duties and obligations through education, then not listing the duties in the Constitution may not affect hinder their implementation. Realizing the importance of the role of education in creating this awareness, the Supreme Court in M.C. Mehta, 2 v. Union of India 1, 1988, 1 SCC 471 held that under Art 51-A, G, it is the duty of the central government to introduce compulsory teaching of lessons on the protection and improvement of the natural environment in all educational institutions of the country. The court also suggested spreading awareness of cleanliness by conducting cleanliness programs in villages, towns and cities. It should be remembered that Art 51A does not contain any provision for the enforcement of duties, and this unenforceability, as with directive principles, has been considered a major drawback. However, we have seen judicial reforms that have helped the situation improve, and responsibilities being enforced. People hardly abide by the Constitution because they hardly follow the law. How many of us obey traffic rules? Our public telephone booths and bus stops are often vandalized, and most of our historical monuments have become canvases for crude graffiti. We see injustice being done to our fellow men at work, in marketplaces and on streets, and all that we do is to stand there as silent spectators. When we want to be heard, riotous behavior is our immediate approach. Environmental awareness needs to be worked hard on. Disposal of domestic and industrial waste in rivers, piles of plastic bags at every nook and corner are just a few problems we face today. Smuggling of our art specimen is rampant. Trade in animal parts is, despite stringent laws, a full-fledged industry. Being a social animal, a human being lives for the good of himself, herself, as well as of others. It is this knowledge of what is right and wrong that makes an individual responsible to oneself and to society, and this knowledge can only be inculcated by imbibing and clearly understanding one's citizenship duties. The fundamental duties are the foundations of human dignity and national character. If every citizen performs his duties irrespective of considerations of caste, creed, color and language, much of the malice of present-day polity could be contained, if not eradicated, and the society as a whole uplifted. Rich or poor, obedience to citizenship duty, at all costs and risks, is the essence of civilized life. Active participation in the governance process is important for a successful, democratic republic. If citizens continue to ignore their responsibilities and fail to discharge their duties, a democratic republic will soon fall weak. 5.8 Summary. The directive principles are like a set of ideals or goals that each government should try and fulfill. The directive principles can also be seen as a check upon the arbitrary use of state power. Though they are not enforceable in a court of law, and we cannot file a case against the government for not being able to realize the ideals of the directive principles, they are far from meaningless. They ensure stability and consistency in the country's development. The directive principles are in Part 4 of our Constitution. They identify a number of inequalities that exist in Indian society and direct the government of the day to work towards eliminating these inequalities. These inequalities could be between men and women, between the rich and the poor, or between people born into different castes. The directive principles also show the path to preserving our heritage and building a brilliant future by projecting India as a leader on the global stage. The directive principles must be read together with the fundamental rights, and the ideals under both have to be protected and realized. It is not as if one must go for the survival of the other. The doctrine of harmonious construction evolved by the Indian courts has provided a clear method of doing this. We have had a mixed record of realizing these ideals, and there is still a lot of work left to be done before we can say that the mission of the Indian state in realizing these directive principles of state policy has been accomplished. The responsibility for doing this is not only that of the government of the day, but also ours as responsible citizens of our country. The very purpose of the fundamental duties is to confer upon every citizen some specific duties to balance their rights. Fundamental duties were incorporated into the Constitution by the 42nd Amendment in 1976. Later on, with the 86th Amendment in 2002, one more duty of providing every child with opportunities of education was added to the existing duties. Part 4A of the Constitution thus enlists 11 fundamental duties in Article 51A. These duties are confined to citizens, and the Indian Constitution is amongst those few constitutions in the world that specifically enlist fundamental duties. By the very nature of these duties, they are not enforceable by law. However, over the years, the judicial and legislative practices have laid great emphasis on their sincere performance. Thank you for watching. We will see you in the next video with the next chapter.